So in 2008, I and some of my partners were called visionaries. You get that label, in case you're wondering, if you have a vision for the future and you see it or you say it before anybody else does. And in 2008, our vision came in the form of alternative fee arrangements. And so enamored with this vision were we that we left our comfortable partnership positions in large law firms across the country, and we formed a new firm called Valorem Law Group. Valorem, loosely translated, means value in Latin. And the purpose for building Valorem Law Group at that time was to provide an alternative to the dreaded billable hour. And in particular, we were focused on litigation, commercial litigation services, and using alternative fee arrangements in that regard. But the interesting thing about visions is that if you wait long enough, the future becomes the present. And shortly after that, it becomes the past, by which you can measure whether you were truly visionary or something else. There's a saying that I'm very fond of by Thomas Edison. It's vision without execution is hallucination. I truly, truly believe in that. So I thought for purposes of this discussion, I would take a look back about our experience with alternative fee arrangements, and I would also take a look forward. Looking back seems appropriate because we're almost at the 10-year mark of that visionary experiment that we call Valorem Law Group. And looking forward seemed appropriate since we are at a futures conference. So in order to frame the question and look back appropriately, I thought I would ask the question, were we truly visionaries or were we just hallucinating? And the answer to that question is yes, absolutely. And I'll tell you why. I'll take the hallucination part first. So before we formed Valorem Law Group in 2008, we spent a great deal of time talking to clients, talking to prospective clients. There were no people who would go to the mat for the billable hour. There were very, very few people who were not looking for some sort of alternative or option because there were none really in 2008. And we were so convinced that we were willing to start a new firm. It was at a time where companies really didn't have the mandate to cost cut as they do today, and most law firms were making profits year over year without any issue. So why the hallucination? Well, when we launched, we underestimated one very, very important fact, and that was the pace at which our profession, or more specifically the lawyers in it, feel comfortable in making change. Guess what pace our profession feels comfortable making change? Probably should have figured this out if I had spent any amount of time thinking about what some of the greatest innovations in the legal profession have been over the last 100, 200 years. I might have remembered that this was probably one of the greatest innovations, the move from this to that. But if you are a disruptor or a rebel of the industry, or really just somebody who's trying to make change, this pace is not particularly disruptive. And it hinders execution, not execution of alternative fee arrangements within our firm. That was not a problem, or with our clients who were early adopters of alternative fee arrangements, but rather execution as a whole in the industry. And if you had asked me in 2008 if I could conjure up a mascot of the alternative fee arrangement movement, this would probably not have been the thing that I selected. But why do I then say that we were potentially on point with our vision? The interesting thing is if you wait 10 years out and you measure how fast even a snail has moved, actually the snail moves. There is progress. And so that is something interesting when you look back. And another way that I measure it is by taking a look at where we were in 2008 to where we are in terms of the sheer adoption of the use of alternative fee arrangements. And if you look at the website, certainly, of pretty much every large law firm, mid-sized law firm, and a lot of the smaller law firms, and you look to see if they say that they do alternative fee arrangements, then in fact you will see that they do. And most people today will say that they have utilized an alternative fee arrangement or that they actually perform legal services using them. And studies have borne that out as well. This is a study from BTI Consulting that indicates that in 2015, $21 billion of legal spend was spent using AFAs. It's comparing it to 2012 when it was only $12 billion. If you compared it to 2008, my guess is there would not have even been a blip of a bar there for 2008. And it's only increased since 2015. And the studies also show that on average, legal companies save about $2.7 million in legal spend annually by utilizing alternative fee arrangements. The other way that I think you can measure whether you are a true visionary is by looking at how many top 10 lists or top 20 lists you make. And we have made our share over the years. So the one that I'm most proud of came out in 2016, and the reason why I'm most proud of it, it is the top 22 law firms best at delivering alternative fees. It's not because we made the list. I would hope that after 10 years of doing this, we're good at doing what we said we were going to do. But it's the company in which we were listed. Firms like Kirkland and Ellis, Morgan Lewis, some of the largest law firms in America. We have less than 10 lawyers. So these are firms that are 100 times our size and probably 100 times our resources. So to me, that was some, validation perhaps of the vision. But in the end, it's up to you to decide. It's really in the eye of the beholder as to whether or not we were visionaries or we were merely hallucinating. So let me tell you a little bit about my thoughts for the future. One reason is because of the workplace of the future. I'll also talk a little bit about alternative fee arrangements plus accessories. And in the end, I'll talk a little bit about what I really think the future is going to be. But AFAs, are they here to stay? I believe that they are, and I believe that they will move forward at more than a snail's pace in the future. It's not because of the traditional reason or the business case that has been given for alternative fee arrangements. That traditional business case is that there are significant cost savings, as we just saw in a previous slide, or because they provide budget certainty to clients, something that they absolutely are demanding and are entitled to, quite frankly. Or because they allow shared risk between the law firms and clients. The real reason why I think that they're here to stay is something that when we talk about the future attorney, I'm talking generational in part, but I'm also talking about diversity in the sense of gender makeup, minorities, et cetera, in the profession. The future is really the millennials, Generation X, who are here in law firms already or in the legal profession already. But the next generation to come upon us will be Generation Z. They're not yet through law school or even in the legal industry, but they will be, mark my words, and they were, as you saw from the photos, weaned on their iPhones. And their tolerance for things that don't match their desired lifestyle is incredibly fleeting, very different than the generations that have come before us. And so I've given a speech in the past. I gave a speech at a conference called Reinvent Law, Silicon Valley, and it was called Tick-Tock, Why Women Should Bash the Clock. And the theory behind it was that I truly believe that the billable hour model disproportionately impacts women. But I've expanded that theory to mean that it disproportionately really impacts anybody who has any responsibilities outside of the workplace that requires an expenditure of time. And the theory behind it is that traditionally under the billable hour model, law firm compensation has been based on two very tangible things. One is business origination, that's easy to understand, and the other is hours billed. And for reasons that really go beyond the scope of this talk, women traditionally, minorities traditionally, and certainly the youngest lawyers, the new generations, are not at the upper levels of the business generation echelon in large law firms or any law firm. And so traditionally, their compensation is driven by the number of hours that they bill. And we all know that when you have competing interests that all take hours and time is finite, at some point in time, no pun intended, there becomes a conflict that often results in some need to make a change. And I truly believe that the reason why there is this enormous leak in the pipeline at the upper levels, equity partner levels of women in large law firms, for example, is because of this inherent conflict and this inherent drag of needing to be in too many places, too many hours, and not being able to deal with it. And so they therefore leave, even though the studies will show that women enter the legal profession at the same rate, if not a higher rate than men in terms of coming out of law school. So in any event, everybody knows that when you have somebody who has more and more things to do on their plate and they want to successfully do it, they have to learn to be more efficient and they have to learn to be more creative. But the problem with the billable hour model is that it doesn't reward efficiency or creativity. It actually, I would argue, punishes it because only more hours garners more revenue for the law firm. Being efficient will only reward you with getting more work to do. It will not reward you with getting a bigger bonus because you short-circuited this really big lawsuit. So how does that translate to alternative fee arrangements? Well, that is truly the answer. If you want a more diverse workforce, and you need a more diverse workforce if you want to keep your clients, if you want to keep the millennials and the Generation Z who will instantly pick up and move law firms or move industries if they're not satisfied with their lifestyle, then you need to figure out how you value the intangibles, how you value quality over quantity, or results and not hours. And the best way to do that, I would argue, is by using alternative fee arrangements, because that's exactly what they're designed to do. They're designed to focus on the end result, and they're designed to incentivize people to be more efficient, to utilize the technology that we're talking about, to lower the costs and to increase the profits. I also believe alternative fee arrangements will remain for those reasons and for the traditional business case reasons, but I think that they need to remain with accessories. Everybody knows that adding something to your outfit can often do wonders, and I think that that's the same with AFAs. Alternative fee arrangements are very good to meet the goals of the client, and you can have a fantastic one and you can have fantastic lawyers. But the truth is, you need to accessorize. You need to use other things in order to enhance that fee structure. So things like early case assessments, so that you're really looking, and there's a lot of technology that helps people do this, you're really looking at matters, litigation, cases from the front end, so you can assess whether or not this is the case that you should be fighting till the end, or this is a case that really begs for early resolution. Second opinions is something that we do at my firm on a fixed fee basis, where we will come in and look at a discrete issue, or we will look at another law firm's strategy midstream and we will weigh in on it. Just like people go to doctors for second opinions from a medical standpoint, so too should they for legal issues. After action assessments, disaggregation, the use of artificial intelligence, workflows, other things that can help from a technological standpoint, will simply accessorize a great alternative fee arrangement and will accessorize a great representation. But finally, not necessarily tied so much to alternative fee arrangements, but I truly think that the future is going to be in something that's highly untapped at this point, and that is just pure prevention. So you could have great lawyers, you can have an amazing fee structure, you can have clients who are thrilled with you, but truly at the end of the day, are clients ever thrilled when they write that legal bill? I don't know. Ask your clients. But at the end of the day, if you as a lawyer can help your clients figure out the root cause of why they have routine litigation that you can really identify, or why is it that studies show that 50% of mergers 5 years out are deemed to have been a failure. Why is that happening? If you can prevent the next lawsuit from happening, then you'll really be in the right place. And that is the vision that I have for the future. So am I correct, or am I just hallucinating? I'm not really sure, but I really hope to see you guys back here in 10 years. Thanks very much.